So with roughly a week now until all the pre-trial proceedings begin, I did want to come back and have a look at some of the state's responses to some of Stearns's motions that were made by his team. As you are no doubt aware, Stearns's defence team have made something in the vicinity of 70 or 80 motions relating to both cases, although I think a lot of them are relating more to the latter trial that we will see possibly at the end of this year. Now, I know there's a lot of people at the moment who are not really watching anything to do with Maddie. I know there's also individuals out there who don't want me to cover Maddie's case and are doing their best to make sure that my Maddie content gets buried. So for those of you who are watching, thank you for your continued support of my channel. It definitely means a lot to me. You can help me out also by hitting the like button, and that will get this out into the algorithm and maybe a few more people might actually see it. Given the extreme likelihood of this video being demonetized, I'm just going to share that there is a link in the description of this video to my Buy Me a Coffee, which is just one way that you can support my channel if you wish to. There's also a link below to my Patreon account. That is entirely free to join. You only need an email address. And on there you can get any documents that I am covering on my channel for free. Basically, once you have become a member, all the documents that I upload are free, and membership is free also. There is a $1 tier and a $2 tier if you wanted to support my channel in that way, but again, that's nothing that you need to do to be able to access documents. The basically membership in Patreon is really just a way of supporting my channel, like the paid membership. The documents that I cover in today's video will be going up onto Patreon while this video is processing, so touch wood, by now they should be there available for you to upload should you wish to do so. I say touch wood because sometimes there's issues with uploads with Patreon and you have to be a little bit patient and go back later on to upload. Now, I've already done one video like this in a similar vein discussing the instructions that Stearns would like to have given to jury members during the pre-sentencing phase. But in this video, I'm going to look at the things that Stearns would like to do with regards to jury selection. Things that clearly his team think will assist with the task of trying to defend the indefensible. All these states' responses have again been penned by the legendary William J. Some of them are quite brief and essentially say, well, duh, but not so much in those words in professional terms, of course, because some of the motions that were put forward by Stearns' team were completely a waste of time. Now, before I jump into this, I am just going to say, if you are not subscribed to my channel yet, please do so, particularly if you are interested in updates with this case, because there is a doozy on the way. I'm still working on getting details of that, but it'll be interesting. So, with that said, let's just jump in and have a look at the state's responses to motions that have been filed by Stearns' team. So, having previously looked at the various motions, I'm not going to be going back over the actual motions themselves, because I think that Will J makes it pretty clear anyway in his responses what it is that Stearns' team is requesting in the first place. So the first one, basically Stearns wants additional preemptory challenges when it comes to jury selection. This is Will J's response. While the defendant has a constitutional right to an impartial jury, there is no constitutional right to preemptory challenges. Preemptory challenges are a statutory creation. Jackson versus State. Florida statute specifically states that defendants facing a sentence of death or life imprisonment will receive 10 preemptory challenges. Because there is no constitutional right to preemptory challenges, the state need only have a rational basis for the statutes in question. Fair and efficient trials is such a rational basis. If during jury selection a need arises for the parties to request additional preemptory challenges, the court has the discretion to grant extra challenges. So, therefore, the defendant's motion should be denied. So basically what he's saying is that there's no constitutional basis for Stearns to be demanding additional preemptory challenges. These are basically something that comes from statute, and that while they can make a request of the judge for additional preemptory challenges, it's not something that should just be given without question. So he's saying basically if they want to make preemptory challenges, they have to be able to justify it to the judge at the time. So basically at the time of jury selection, then if they can come up with a damn good reason why they need additional preemptory challenges, yes, they can then petition the judge for that. As for just granting them regardless prior to the trial, basically he's saying, yeah, nah. You get your 10 preemptory challenges. Anything after that, that comes down to judge's discretion during selection. So essentially, Stearns' team want these preemptory challenges without having to justify any reason for having them. Now this one is somewhat devious on the part of Stearns' defence team, and I'll come back to that shortly. So the state's response to defendant's motion for compensation of juror at current wages and for reimbursement to primary caregivers for daycare costs. A juror's compensation is a matter of legislative authority and not judicial prerogative. The defendant has failed to demonstrate that Florida statute violates the fair cross-section of the community guarantee of the Sixth Amendment. In order to establish a prima facie violation of the fair cross-section requirement, the defendant must show 1. That the group alleged to be excluded is a distinctive group in the community. 2. That the representation of this group in veneers which juries are selected is not fair and reasonable in relation to the number of such persons in the community. And 3. That this underrepresentation is due to systematic exclusion of the group in the jury selection process. While the defendant's motion avers that the statutory compensation of jurors makes is practically impossible for wage labourers to serve on juries, there is no indication that these groups are actually underrepresented in the group from which the jurors are selected, or that they are systematically excluded even if the court were to recognise these as distinctive groups. Therefore, the state requests the court to deny the defendant's motion. So why the concern over these particular groups of individuals being underrepresented? Quite plain and simple. Their focus here for jury selection is not about a verdict. It's about avoiding the DP. The two groups identified here are amongst the identified groups of people who are less likely to be in favour of a DP. So by trying to weight the jury, by trying to have people on a high income, people with young children, basically they're recognising here that they are going to get a conviction. But the goal here is to get a life sentence rather than the alternative. And again, this particular motion that we have a response to is also aimed at having your middle class white male on the jury. State's response to defendant's motion for discovery of prosecutorial investigation of jurors. Argument: criminal defendants do have a right to pre-trial discovery under Florida Rule of Criminal Procedure. As soon as practicable after filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant. However, nothing in Florida Rule of Criminal Procedure entitles the defendant to the discovery of prior criminal history of or information about potential jurors beyond the confines of Brady, which the state has already agreed to disclose. There is no general constitutional right to discovery in a criminal case, and Brady did not create one. This is evidenced by the repeated refusal of Florida's appellate courts, and he's kind of messed up a bit here, have repeatedly refused to order the type of broad disclosures the defendant seeks here without first demonstrating his efforts to obtain the information they seek on his own. Both the First and Second District Courts of Appeal have considered and rejected defendant's assertion he is entitled to the prior criminal history of prospective jurors. In Monahan v. State, the First District Court of Appeal affirmed the trial court's denial of the defendant's motion for discovery of criminal records of prospective jurors and state witnesses. The Monahan court dealt with the request as to the jurors succinctly. Appellant has cited no authority to support his contention that the state should have supplied him with the criminal records of the prospective jurors, and we know of none. The Second District Court of Appeal reached the same result in Robertson v. State, affirming the trial court's denial of the defendant's motion for copies of complete and detailed reports on any and all prospective jurors. Florida courts have therefore recognised defendant is not entitled to the prior criminal history of potential jurors beyond the requirements of Brady. Assuming the defendant could point to some binding authority for the state to disclose this information, the defendant would still need to show due diligence in attempting to obtain it on his own before the court could require disclosure. The Florida Supreme Court has approvingly quoted the following when discussing a prosecutor's discovery obligations outside of Brady material. The underlying principle supporting the whole idea of criminal pre-trial discovery, as gleaned from the cases and well-reasoned commentaries, is fairness. But no intelligent concept of fairness has ever been advanced which would require one side of a judicial controversy to prepare the case for his adversary, or to furnish such adversary with evidence favourable to him when such evidence is otherwise reasonably available. And the unique aspects of the criminal law do not require that such a concept should be any more appropriate in a criminal case than in any other. So, in a nutshell, it is not the job of the prosecution to actually do the defence's work for them. There's more precedents cited there, but I won't go through all of it. But I will just go from, put simply, the state has no duty to do for the defence work which the defence can do for itself. The defendant cites no case law which supports the state is required to disclose prior criminal history, especially if defence counsel has demonstrated no efforts to obtain those records. With reasonable diligence, defence counsel will likely succeed in procuring the venire member's arrest history and information from social media platforms. The Orange County Clerk of Court's website makes public records readily accessible, so any user of the website may search for a person's criminal history. A Google search of a person's name allows the seeker to view whether that person has any social media account. A juror's social media website account can be readily available to any user of the website, depending on whether the account holder's privacy settings are public or not. The state accesses what is publicly available on social media sites. The information the defence seeks to compel from the state is equally available to the defendant through his counsel without having to compel disclosure from the state. So he's basically saying, this is how to do your job. It doesn't take a genius to figure it out, so pull your thumb out and just do it. I really do think I am going to enjoy Will J's rebuttals in this case, because this guy is sharp and he sounds like he has a slightly devious sense of humour. Wherefore the state requests this court to deny the defendant's motion for discovery of prosecutorial investigation of jurors. So why is this something that's important to Stearns' team? Again, social currency. While it obviously isn't a surefire thing, but there is of course that element where people with criminal history, many of them will come from a low socio-economic background and are therefore the sort of people who probably would vote in favour of the DP. So for Stearns' team, it's important to be aware of criminal history of potential jurors so they can weed out the ones that may be in favour of DP based on their background. And Will J's response is quite appropriate. Do your own work, it's not our job to do your work for you. So it seems that there's a few motions that are being put forward by Stearns' team where they're basically asking the state to do their work for them. So this one is quite succinct. obviously the motion put forward by Stearns' team is designed to avoid tainted juries. But, some of it yes, some of it no. Again, though, it is an attempt to control jury selection in their favour. So, State's response to defendant's motion for individual voir dire, I know, I get it wrong every time, as to death qualification, publicity and hardship. 1. The State agrees that potential jurors should discuss any pre-trial publicity individually to not taint the other members of the panels. Essentially, they don't want to be asking jurors, do you know anything about this case? And someone blurts out half the stuff about the case in front of the rest of the potential jurors, because that's going to be a problem. And then he cites Neal versus State. The trial court in this case agreed to individual voir dire of prospective jurors having any previous knowledge of the case, including from pre-trial publicity. Hardship and scheduling issues can be safely discussed in large groups. 3. Death qualification questioning can be accomplished with smaller panels of jurors, groups of 5 or 10 at a time. The determination of whether to grant individual or sequestered voir dire rests in the trial court's sound discretion. San Martin versus State. Therefore, the defendant's motion should be granted in part regarding jurors who indicate they have exposure to pre-trial publicity, and denied without prejudice until the need for individual voir dire is developed during jury selection for hardships or death qualification. So, without prejudice meaning that, as a rule of thumb, it should be denied. It can't be something that they just get granted regardless. However, if there is a particular issue that arises where they feel that there is a need for individual voir dire, then they can request that of the judge, and then it's up to the judge to say yes or no. Now, this one is a slightly odd one, and I haven't quite wrapped my head around it yet. State's response to defendant's motion for personal service on potential jurors who do not respond to their summons, and for the court to determine all excusals. Florida statute outlines which citizens are disqualified from jury service and who may excuse someone from jury service. A trial judge may delegate the task of excusing jurors that are prohibited from serving or that have the option of refusing to serve. So essentially, it comes down to the judge to decide who can be excused and who has the option of refusing to serve, but the judge can delegate that task. A trial judge is not required to oversee every excusal from jury service. This does not defend a defendant's right to be tried by a jury representing a cross-section of the community. In other words, just because the judge doesn't oversee it doesn't mean this is denying the right of the defendant to be tried by a cross-section, because obviously whoever is appointed by the judge to do the job is going to be appointed because they are capable of doing so and understand the rules and protocols, etc. The defendant fails to allege what particular cross-section of the community is more likely to fail to appear for jury service. Florida statute outlines the process for summoning jurors. There is no requirement for in-person service, and the statute outlines a penalty of a $100 fine or punishment as contempt of court. Also, there is no practical way to do what the defendant requests. We will not know which jurors fail to appear until each day a panel is summoned. It is impractical to suggest that we wait for personal service to then be had on each juror, under no statutory authority to do so, and then proceed with jury selection. Therefore, the defendant's motion should be denied. Honestly, all I can think of here is that the defence is being lazy. They want to be able to go through the list of potential jurors and select the ones that they really want and not have to put in extra work to have more potential jurors up their sleeves from that pool in case someone doesn't turn up for jury service. That's all I can see with regard to this. So it seems like their concern is that someone that they may believe is going to be an ideal juror might choose not to turn up, and that will mean extra work for them or make it harder for them to choose their perfect jury. So basically I think this is about them wanting to do bare minimum work in terms of jury selection, which is ridiculous given that they are attacking jury selection so much. You would think that they would actually want to make this one of their pre-trial priorities. Okay, so this one is state's response to defendant's motion in limine to prohibit prosecution from challenging certain potential jurors for cause. This one's got me a little bit baffled as well. The defendant has requested this court to enter an order limiting the dismissal of trial jurors because of their attitudes towards the DP. He claims that allowing the dismissal of trial jurors on this basis deprives him from having a fair cross-section of the community serve on his jury and creates a jury that is conviction-prone. The defendant appears to suggest that this court will only allow dismissals for cause of jurors based on their attitudes towards the DP after the issue of guilt has been decided. The state maintains that defendant's request is untenable. I'm still not quite following. The defendant begins his motion by stating that prospective jurors who have reservations about capital punishment but which would not affect the verdict in any manner may not be properly challenged for cause by the prosecuting attorney, in paragraph 1 of his motion. Then he states in paragraph 2, a prospective juror who has reservations about the DP but whose attitudes would not prevent him from making an impartial decision as to the defendant's guilt or innocence may not properly be excused for cause by the prosecuting attorney. Interestingly, the defendant then states in paragraph 5, while prospective jurors with reservations about capital punishment as described above might properly be excluded for a jury impanelled to make a recommendation as to penalty in a capital case. The state is at a loss for how to respond. Okay. Can prospective jurors with reservations about capital punishment as described by the defendant be excused for cause or not? What does reservations mean? Does that include potential jurors whose reservations are firmly fixed beliefs, or merely potential jurors who express opinions for or against the DP but will follow the law? Condi v. State. In a DP case, a juror is only unqualified based on his or her views of capital punishment if he or she expresses an unyielding conviction and rigidity toward the DP. The defendant appears to be using reservations as meaning both classes of jurors. The state suggests that this confusion could be avoided by not citing cases, as the defendant does, that predate the abolition and reinstatement of capital punishment. It is clear this analysis using the term reservations predates Furman versus Georgia. A man who opposes the death penalty, no less than one who favours it, can make the discretionary judgment entrusted to him by the state and can thus obey the oath he takes as a juror. But a jury from which all such men have been excluded cannot perform the task demanded of it. Guided by neither rule nor standard, free to select or reject as it sees fit, a jury that must choose between life imprisonment and capital punishment can do little more, and must do nothing less than express the conscience of the community on the ultimate question of life or death. The DP was deemed unconstitutional in 1972. Furman versus Georgia, US 238. No longer was the defendant in a capital crime subject to the whims of the conscience of community standard, without a far more elaborate capital sentencing scheme which required jurors to follow the law and not their hearts. Shortly after Furman, the Florida legislature enacted Florida Statute 921. Since then, as this court is well aware, the Supreme Court in Lockhart versus McCree has held that separate juries are not required in capital trials. The Supreme Court also authorised the death qualification of prospective jurors prior to the guilt phase of a bifurcated capital trial. Furthermore, the Supreme Court held that the death qualification of prospective jurors does not violate the defendant's right to a trial by a jury representative of a fair cross-section of the community and does not result in a conviction-prone jury. So if you remember, one of the things that Stearns' defence put forward was that they wanted separate juries so that the jury responsible for the penalty phase was not the jury that decided guilt in the first place. Like, it makes no sense. Florida statute provides for exclusion of jurors in a capital case for those who are unable to set their personal views aside with regard to the death penalty. Despite defendants' assertion that this concept is unconstitutional, the statute has been repeatedly held to withstand any constitutional infirmities. Accordingly, this court must deny defendant's motion where defendant is entitled to only one jury, and the state may excuse for cause a prospective juror whose views on the death penalty would prevent or substantially impair the performance of his duties as a juror in accordance with his instructions and his oath. Wherefore, the state requests this court to deny the defendant's motion in limine to prohibit prosecution from challenging certain potential jurors for cause. So they're trying to limit who the prosecution can challenge based on cause. And it sounds like basically what they're coming at there is that they don't want the prosecution to challenge any jurors that say that they are not going to vote for the death penalty because that's what they believe in. In other words, they want to prevent the prosecution from excluding any jurors who are so dead set against the death penalty that they won't actually vote for it. They want to weight the jury in their favour. And they also point out that the defendant is entitled to only one jury, not one to make the guilt decision and then one to make the sentencing decision. This one is brilliant, short and sweet, and it shows that the defence clearly don't know the law that well. State's response to defendant's motion to allow questions on jurors' religious beliefs during individual voir dire. And basically, their response is the parties are allowed to inquire about potential jurors' religious beliefs that would preclude them from following the trial court's instructions on the law. Full stop, end of story. It's a ridiculous motion because basically you filed a motion for what is essentially standard practice and covered by precedent. Again, we have another motion where the defence is trying to limit the prosecution when it comes to jury selection. So this is the state's response to defendant's motion to challenge to the jury panel. 1. Disqualification for jury service based on criminal history pursuant to Florida statute serves as a rational basis. Meaning, sod off, we can challenge a juror and have them disqualified based on criminal history. 2. Disparate racial impact alone is insufficient to trigger the strictest level of scrutiny. US versus Green. Absent evidence of a purposeful intent to discriminate, the rational relationship test applies. Meaning it shouldn't be about racial backgrounds, but about individual jurors and their own beliefs. 3. Convicted felons are barred from serving on juries in most jurisdictions in the United States. Then we have, therefore, the court should deny the defendant's motion because disqualification for jury service based on criminal history serves a rational basis. Basically, there is precedent for it. It is allowed. As for looking at racial impact, shouldn't be on race alone, but on individual jurors' views. And clearly this need to allow felons to serve on a jury is important to the defence team because they've taken a swing at it from a few different angles. So the next thing we have here is state's response to defendant's motion to declare Florida statutes exclusion of felons from jury service unconstitutional. And Will J basically gives exactly the same argument for this one as he did in the previous one. Basically, the things he outlined, it is actually covered with under precedent, under Florida law, and is of course the same in most jurisdictions in the United States. Obviously, Stearns' defence thinks that if they can get a few felons on the jury, those felons might be against the death penalty and therefore might help him to avoid that part of it. And then we have another attack on Florida statute. State's response to defendant's motion to declare Florida statutes or the standard instruction unconstitutional facially and as applied. The argument here, defendant complains that Florida statutes 921.141 blah 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 and the corresponding standard jury instruction are unconstitutional as being vague and overbroad, and that this aggravating factor has been applied in an arbitrary and inconsistent manner. Subsection 6b relates to the prior violent felony aggravating factor. Oh, I get this. This is basically because of this first trial. If he gets a conviction with that, then it will be considered an aggravating factor, when it comes to the sentencing phase in the second trial, and he wants to declare that unconstitutional. In other words, he doesn't want the jury to consider his other actions relating to Maddie when they are considering his sentence for the second trial. Now, Will J throws in a lot of precedents here. I'm not going to read through them. But what he said here is, initially the state would point out that the constitutionality of Florida statute has been repeatedly upheld by the Supreme Court of Florida and the United States Supreme Court. Claims that Florida's death penalty statute violates Florida federal and international law have also been rejected. The same holds true for claims that Florida statute is unconstitutionally, facially, and as applied. Furthermore, all recent constitutional challenges based upon Apprendi versus Jersey, etc., have also been rejected by the Supreme Court of Florida. Regarding Florida Statute 921.141.6b, the state would point out that the constitutionality of this aggravating factor was approved in profit supra, as was the direction given the judge and jury. Furthermore, the constitutionality of this aggravating factor has been upheld by the Supreme Court of Florida post Ring and Apprendi in Henry v. State. The court has specifically held that the prior violent felony aggravating factor, when based on contemporaneous crimes charged by indictment and on which a defendant is found guilty by a unanimous jury, clearly satisfies the mandates of the United States and Florida Constitution. In other words, it is entirely constitutional. There is plenty of precedent, so no, you can't prevent us from citing your conviction, which will soon occur, for all the CSAM stuff as aggravating factors, because it is based in law. We are allowed to do that. Wherefore, the state requests this court to deny the defendant's motion to declare Florida sections or Florida statutes or the standard instructional unconstitutional facially as applied. Clearly, Stearns' defence realise how bad it is going to look for him when it comes to the second trial, if, or we should say hopefully when, he has that first conviction relating to CSAM materials, especially because that relates directly to Maddie. So they would much rather the jury not be told about that. And another one that's basically pointing out the fact that Stearns' defence team really don't understand the law. State's response to defendant's motion to preclude the state from using preemptory challenges to exclude potential jurors on the basis of their race. So the defence don't want the state to be able to make challenges to exclude jurors based on race. Okay, so what is the response? Neither party is allowed to exercise a preemptory strike against a potential juror because of the juror's immutable characteristics such as race. In other words, this whole motion is a load of hooey. The process for determining if an attorney's proposed preemptory strike is being used for improper purposes is outlined in Melbourne v. State. The court should follow the law if either side objects to the opposing party's use of a preemptory strike. So essentially, in short form, dear prosecution, your motion is completely stupid because actually it's all covered under the law anyway. So it seems like the common theme is that the prosecution have thrown in all these motions that have no basis in legal precedent or in the Constitution. State's response to defendant's motion to prohibit questioning of potential jurors as to their willingness to render a verdict for the death penalty. Argument: the defendant requests this court to completely prevent the state, and presumably himself, from questioning jurors about their views on the death penalty so that the state, and presumably himself, can ascertain whether those views would prevent or substantially impair the juror's ability to perform his or her duties. Defendant's request is contrary to well-established United States Supreme Court precedent and Florida Supreme Court decisions and Florida statutes. The United States Supreme Court held in Wainwright v. Witt that the standard for excluding a juror for cause based on the juror's views on capital punishment is whether those views would prevent or substantially impair the performance of his duties as a juror in accordance with the instructions and his oath. This standard was reiterated by the Florida Supreme Court in Castro v. State. Citing Witt for this language and noting this standard likewise does not require that a juror's bias be proved with unmistakable clarity. The Wainwright Court explained, however, that more recent opinions of this court demonstrate no ritualistic adherence to a requirement that a prospective juror make it unmistakably clear that she would automatically vote against the imposition of capital punishment. In applying this test, the Florida Supreme Court in Hill v. State explained, "It is exceedingly important for the trial court to ensure that a prospective juror who may be required to make a recommendation concerning the imposition of the death penalty does not possess a preconceived opinion or presumption concerning the appropriate punishment for the defendant in the particular case. A juror is not impartial when one side must overcome a preconceived opinion in order to prevail. When any reasonable doubt exists as to whether a juror possesses the state of mind necessary to render an impartial recommendation as to punishment, the juror must be excused for cause." And all those precedents say pretty much the same thing, basically. If it appears that the juror cannot make a recommendation for a death sentence based on their own beliefs, then that juror needs to be struck. So just going down to the bottom here, it should be obvious, he is really having a go at the defence here, that in order to determine a juror's ability to follow the law and consider whether the death penalty is the proper sentence if the defendant is found guilty, both parties should be permitted to question each juror about his or her belief and ability to consider a sentence of life or death. The defendant claims that asking a potential juror whether he or she would vote for a death sentence is impermissibly asking a juror to commit to a verdict. No. The state does not dispute the holding of Rennie and agrees that it is impermissible to request a juror to commit to a specific verdict or specific sentence in a capital context. However, asking a potential juror whether the juror would vote for a sentence of death is a vastly different question than if the juror could vote for a sentence of death. The former is impermissible based on the case law. The latter is necessary to identify potential bias. So he's saying that, obviously you're not going to ask a juror to commit to making a decision where they say, yeah, okay, go with the death penalty. You can't do that because that's illegal. But you can ask them if their personal beliefs are going to prevent them from making that decision should they be required to do so. The defendant again addresses the propriety of exercising preemptory challenges on jurors who are opposed to the death penalty. This challenge has been the subject of several motions defendant has filed and to which the state has filed responses. Therefore, the state will rely on his previous responses as it pertains to those issues. In other words, you're just repeating yourself. Defence team, get over it, accept that this is how the law works. The defendant finally appears to argue that death qualifying a jury is impermissible because it leads the jury to believe that the defendant is already guilty. And here we go back to the discussion on separate juries. This court is aware that the Supreme Court in Lockhart v McCree has held that separate juries are not required in capital trials. The Supreme Court also authorised the death qualification of prospective jurors prior to the guilt phase of a bifurcated capital trial. Furthermore, the Supreme Court held that the death qualification of prospective jurors does not violate the defendant's right to a trial by a jury representative of a fair cross-section of the community and does not result in a conviction-prone jury. Wherefore, the state requests this court to deny the defendant's motion to prohibit questioning of potential jurors as to their willingness to render verdict for the death penalty. So it seems like Stearns' defence just wants to throw out all statute, all pre-existing law, and tell the judge how they want to select the jury. I'm surprised there isn't a motion for the defence to be allowed to select the entire jury themselves without any argument from the state. And the final one here, which is another one that makes absolutely no sense, state's response to defendants' objections to the use of follow-the-law questions to rehabilitate or qualify jurors. In other words, they don't want the state to be asking jurors if they will follow the law. Like, hello? In a death penalty case, a juror is only unqualified based on his or her views on capital punishment if he or she expresses an unyielding conviction and rigidity towards the death penalty. In Conde, Aveneerman initially stated that the death penalty should be mandatory in some circumstances, but later indicated he could follow the law on weighing aggravators and mitigators. His answers revealed that he did not have an unyielding rigidity toward the death penalty, whereas here a prospective juror initially states that one who murders should be executed, but later states he can follow the law upon court instruction. The trial court does not abuse its discretion in denying a cause challenge. Therefore, both the defendant and the state should be permitted to inquire of prospective jurors if their opinions about the death penalty are rigid and unyielding, or if their opinions are not so inflexible that anyone has a reasonable doubt about their abilities to follow the law. This, of course, requires allowing both parties to ask if, after further questioning and explanation, the prospective juror can follow the law that the court will instruct him or her on following. After thorough questioning by the parties, the proper standard for the court to apply is whether a potential juror's views prevent or substantially impair the performance of his or her duties as a juror. If a reasonable doubt exists about the juror's impartial state of mind, the juror should be excused. Here again, the question of whether a potential juror could follow the law was permitted as appropriate. To the extent that the defendant's arguments and cited authorities stand for the idea that simply asking if a potential juror can follow the law is woefully inadequate, especially in a capital case. The state agrees with the defendant. Both parties need great leeway in exploring the potential veneer about their feelings regarding capital punishment. Therefore, the defendant's objection to either party or the court inquiring whether a potential juror can follow the law should be overruled. So basically, it sounds like what the defence wants here is that if a juror expresses that they are not a fan of the death penalty, then the defence doesn't want the state to actually have to ask them, but if it came to it, would you follow the law and make a decision? I think instead the defence would rather just strike those particular jurors just on the off chance that they might vote for a death penalty. So again, these motions are all about stacking things in favour of the defence. I think from what we've seen, pretty much all the motions that have been put forward by the defence team are based on the belief that he is going to be convicted, and they're basically attacking any processes that are going to result in him getting the death penalty. So they're attacking jury selection because they want control over that so that they can have the right jurors. They're also attacking the pre-sentencing phase so they can have control over how that is done. And of course they are attacking Florida statute left, right and centre for all sorts of things, which it's just a joke. They're a joke. Now, I don't know enough about what goes on in the background during trials in terms of what other team members are doing outside of the courtroom. But my observation here is that unless the defence team have a few extra members of their team in the background for checking on statute, checking on all those sorts of things, precedents, then they're going to be in deep water during this trial. Because it seems that at least those of them who are heading the team either have a rather poor understanding of Florida statute, of precedents, of all these things, or they're just trying to get these things through and think that maybe the judge or the state's team will be somewhat ignorant of Florida statutes, Florida laws, constitutional stuff, precedents, all these things, which is pretty naive, really. I know this has been a kind of weighty video, one that requires a bit of concentration. So thank you to those of you who have persevered and stuck it out to the end. I greatly appreciate you for doing that. So before I lose my voice from reading through all these documents, I'm going to finish here. So thank you for listening. Please hit the like button because that'll get this video out there into the algorithm. And of course, please leave a comment below. Thank you, and I'll catch you in the next one.